Okay guys, let's keep going here. This is lesson 2 of Colorado Real Estate Contracts. We're in the manual 2015 and we are on page 139. Let's look at the broker's disclosures. Very bottom of the page, third paragraph from the bottom. Let's read this. Any person, firm, partnership, limited liability company, association, or corporation acting as a broker shall adopt a written office policy that identifies and describes the relationships offered by the public. Every company you go to work for will have an office policy manual. Yeah. On page 1-39, bottom of the page there. And ask them to read that office policy manual before you go to work for them. And the purpose of the office policy manual is just that. The relationships that are offered to the public. There's a ton of other stuff in there, but that's the main purpose of the office policy manual. And that's on the state exam guaranteed question. And some, like my office policy manual is 7-8 pages, double spaced. You can read it in 20 minutes. I've seen some that are a phone book. Ridiculous. The broker you're going to work for doesn't know what's in that thing, let alone you. So again, make sure you understand what you're getting into when you go to work for a company. And we'll study this office policy manual in much greater detail when we get to the trust account part of the course.
Who comes up with it?
Who does it? Who comes up with it? The employing broker comes up with it, and he designs it. And there's outlines within this manual that tells you what should be in there.
So why would he want to make a phone book more than an office policy?
Why would he want to make a phone book? Because what's happened, he's got his attorneys involved, and they got to earn their living. Let's go to page 1-40, and let's go to D1, below the middle of the page there. D1, 2, D1. Prior to engaging in any of the activities enumerated in the state statute, the brokers intending to work with a buyer or seller as an agent of the seller or landlord shall provide a written disclosure to such buyer or tenant that shall contain the following: a statement that the broker is an agent for the seller or landlord and is not an agent for the buyer or tenant, a list of the tasks that the tenant intends to perform for the seller or landlord with the buyer or tenant, and a statement that the buyer or tenant shall not be, and the reason I'm reading this is for this one word, vicariously liable for the acts of that person. Now, vicarious liability disappeared about 12 years ago. And the way it used to work was this. You could actually be co-liable with someone for what someone else did while they were representing you. Let's say I had a listing on these people's house, a nice listing, $1.5 million property, let's say $3 million property. And I sold both ends. And it's a 7% commission. I'm so happy. And I get both sides of it signed, and I've got the earnest money check, and I remember I'm the broker, I've got the list, and I go to bring the check to the bank, and to celebrate, I stop and have a 3-martini lunch, and I get a DUI and get in an accident, and I get sued. They could actually sue the seller also, involve him in that lawsuit. Isn't that something? Is that the craziest law you ever heard? And this was on the books for years, where you could get sued for a mistake that somebody else made if they did it while they were representing you. That's vicarious liability. There is no more vicarious liability. On the state exam, you will see that word. If you see vicarious liability in the answer, that's the answer. Most of the time, okay? There is one question where vicarious liability is not the answer, but you'll be ready for it. You'll be ready for it. You will definitely have one question where vicarious liability is in the answer, probably 2. And you'd be safe marking both of those as the wrong answer. Well, one of those, vicarious liability, is not the right answer. So just kind of feel it out. Feel it out. You'll be okay. I'll hit you with both those questions here in class. Now, let's go to page 1-41. Third paragraph from the top. The relationship set forth in this section 8 shall commence at the time that the broker is engaged by a party and shall continue until performance or completion of the agreement by which the broker was engaged. This is for the listing contract. If the agreement by which the broker was engaged is not performed or completed for any reason, the relationship shall end at the earlier of the following: any date of expiration agreed upon by the parties, any termination or relinquishment of the relationship by the parties, or, this is huge, 1 year after the date of the engagement. A listing can never be for more than 1 year. We're going to be talking about something called a holdover clause. What a holdover clause is, I have a listing on this property for 3 months. It's a 3-month listing, let's say. And anybody that I showed this property to during my 3-month listing, that I let the seller know in writing that I showed it to these people. I have a sign-in book or something is the best way to do it. And let's say my listing ends and I don't sell the property, and the seller takes it off the market or lists with another broker. I can have what's called a holdover period. If I have a 3-month listing, I'll take usually a holdover period for that same amount of time. I'll have a 3-month listing and a 3-month holdover. During that holdover clause, anybody I showed that property to while I had that listing, maybe they had a home to sell, and they call me back and they say, I finally sold my home. Remember that house you showed me 2 months ago? I'd like to see it again. I can bring them into that home and get my full commission, even though my listing has ended, because it happened while I had the listing on that property. Even if that seller lists with another broker, I can bring that person in and knock that new broker right out of the deal.
What if it's in contract? What if there's a contract on it? Do you still come in and knock it out?
What if there's a contract in it? My holdover clause does not end until that new broker does something that merits a commission. Not only has a contract on it, but has a contract and closes it.
Wow.
That's the end of my holdover.
That's crazy.
Yes. And we'll talk about that in black and white. It'll be right on the listing contract when we go over it.
Does it
Yeah.
have to be you just showing it to the client, or can it be a client's agent?
A client's agent.
So, like, you know how sometimes brokers have like a broker's open
Yeah,
house?
okay, so a buyer's broker brought it into my property.
Mhm.
And then they come back later and do it. You could press the issue for that because you were still what's called the procuring cost of doing it. But mainly this is for people that you yourself have brought into the property. What this is to keep from happening is you're sitting there showing these people a property, and all of a sudden the seller shows up. You want the seller to be out of the house whenever you're showing a property. Well, let's say the seller shows up, and so you're downstairs, you're in a room, and you're talking, the three of you kind of shooting the bull, and you get a cell phone call, and you say, excuse me, I got to take this, and you go around the corner, and while you're around the corner, the seller looks at that buyer and says, you know, my listing ends in about 3 weeks, come see me, I'll make you a heck of a deal. That's to keep that from happening, primarily. But again, we will look at it when we get to the listing contract in black and white.
Are there certain situations where the buyer has to be present? I'll just give you an example. I knew somebody that was looking at buying houses, or buying a house. They happened to look at one of the Columbine killers' homes, and the parents asked they be present every time that home was shown. Is there a reason for that?
You can have it that way, however the seller wants to do it. And can the seller insist they're there every time you have a buyer come to that house? Yes, you can.
Okay.
However they want to do it. How do you want to handle it? You want those sellers as far away from that home as you can get them.
They have surveillance cameras.
Yeah, really. But yeah, you really do. Want them as far away from there as you can.
When you're using the 2 to 3 months for the clause, are you using that as an example of how long it could be, or is that actually
You don't even.
most common?
You know, is that what it has to be, 2 or 3 months? No. But your listing and holdover clause combined cannot be over a year. Okay, now, you know, not in this crazy market, but several years ago, what I did is I pulled up all of the homes from $1 million to $10 million and see how many were on the market. And then I pulled up how many closed in the last year. And the typical $1 million house at that time was taking 5 years to sell. That was typical. You know, now it's an insane market out there. But anyway, But what are you gonna do? What's a 1 year listing when the average time is 5 years? You've gotta be able to tell your people, when that's the case, you know, the average time is 5 years to sell this this $1 million property. And I can't give you more than a 1 year listing. I'll give you a 1 year listing that will automatically renew itself with a new contract at the end of every year is pretty much how you wanna have it. So,
And for each time that it renews, you get a holdover.
and every time that it renews, you get that new 1 year going on, yeah. And then that holdover can fit in there somewhere if you wanna use a holdover. I've never seen a deal where the holdover clause has ever come into play, ever. Very rare. Let's look at the bottom of page 1-41. Look at compensation. Compensation. Number 1. Bottom of page 1-41. In any real estate transaction, the broker's compensation may be paid by the seller, the buyer, the landlord, the tenant, a third party, or by the sharing or splitting of a commission or compensation between brokers. We don't care who pays us. And payment of compensation shall not be construed to establish an agency relationship. Remember, I told you in some states it does. A seller or landlord may agree that a transaction broker or single agent may share the commission or other compensation paid by such seller or landlord with another broker. And we can't even pay a co-oping commission without the seller's permission. And a buyer-tenant may agree that a single agent or transaction broker may share the commission or other compensation paid by such broker or tenant with another broker. Top of the next page. A buyer's tenant agent shall obtain the written approval of such buyer or tenant before such agent may propose to the seller or landlord's agent that such buyer's or tenant's agent be compensated by sharing compensation paid by such seller or landlord. And prior to enter into a brokerage or listing agreement or a contract to buy, sell, or lease, the identity of those parties, persons, or entities paying compensation or commission to any broker shall be disclosed to the parties to the transaction. And a broker may be compensated by more than one party for services in a transactions, if those parties have consented in writing to such multiple payments prior to enter into a contract to buy, sell, or lease. We can get paid any way we want to. We can get paid with jewelry. We can get paid with anything. If you're working on farms and ranches, might get paid with a tractor or an animal of some kind. There's no way of telling. I did one deal one time, and my commission was they put new windows in my house. Anything you want to do. Let's go to page 2-2. And this is, look at A11, middle of the page, A11. What's going to happen? Let's just read this. An applicant for a Colorado real estate license who has held a real estate license in any other state must file with the application for a Colorado license a certificate of licensing history. Highlight that. So if you're going to another state or someone's coming from another state to Colorado, that state will ask you for a certificate of licensing history, and the two states are the ones who are going to send them back and forth to each other. But a certificate of licensing history, they want to see if they've ever suspended your license or did something like that in one of the other states.
Which one was that?
A11. A11 on page 2-2. Let's get over to page 2-4. And look at this A25, middle of the page. A25 talks about a non-sufficient funds check voids the application. What happens if you give a check to the Real Estate Commission to get your license and it bounces? This is kind of wild. Let's read this. If the fees accompanying any application or registration made to the Commission, including fees for the recovery fund, renewals, transfer, etc., are paid for by check, and the check is not immediately paid upon presentment to the bank upon which the check was drawn, the application shall be canceled. The application may be reinstated, listen to this, only at the discretion of the Commission, and upon full payment of any fees together with payment of the fee required by state fiscal rules for the clerical services necessary for reinstatement. So if that check bounces, they're going to have a meeting to see if they'll even let you reapply. You know, if that check, that's one of the most important checks you're gonna write your entire life. If that check bounces, that might be all they need to know about you. So, you might wanna use certified funds or a bank draft or something, kinda play it safe. And, temporary broker's license, pursuant to the state statute, a temporary broker's license may be issued to a corporation, partnership, or LLC company to prevent hardship. No application for a temporary broker's license will be approved unless the designated individual is a Colorado real estate broker with, there it is, 2 years of active license experience, as indicated by the records of the Real Estate Commission. And no more than 2 temporary licenses may be issued to any corporation, partnership, or LLC. And again, that's one where they ask, who would they get? And that's someone with 11 years experience. And when is continuing education required? Look at this B1. The commission has determined that the license renewal process may be made more efficient by apportioning license renewals throughout the entire calendar year. Brokers must satisfy the continuing education requirements prior to applying to renew an active license, to activate an inactive license, or to reinstate an expired license to another status. All license renewals shall be for a full 3-year period called the anniversary date renewal period. The period shall commence on the broker's initial date of issuance, the anniversary date, and expire 3 years later on the broker's anniversary date. Over and over and over in this book it says it expires on December 31st. That's not true anymore. It expires every 3 years on your anniversary date, so make sure you put a big star by that. Last paragraph. Method of completing a continuing education. Licensed brokers must satisfy the continuing education requirements before they apply to renew an active license, activate an inactive license, to reinstate an expired license to active status. Licensed brokers may satisfy the entire continuing education requirements through one of the following options. Top of the next page. Complete the 12 hours required, that's the 12 hours, 4 hours every year, by this rule in annual 4-hour increments developed by the Commission, otherwise referred to as the Annual Commission Update Course. Licensees who choose this option must complete an additional 12 hours of elective credits hours to meet the 24-hour total continuing education requirement during the license period in subject areas listed in that state statute. Please note that the licensee may not take the same version of the Annual Commission Update Course more than once. If a licensed broker takes more than 12 hours of the Annual Commission Update Course during a license period, the licensee will receive elective credit hours for any additional hours. So there again, the 4 hours every year plus 12 hours of electives, or complete the commission-approved 24-hour broker reactivation course. This option is available to licensees under one of the following conditions. The licensee is currently active and did not use the broker reactivation course to satisfy the rules requirements in the previous license year. The license is inactive or expired for up to 36 months prior to activating an active license or reinstating an expired license to active status and unable to comply with the education requirements. Or you can pass the Colorado portion of the state exam, or complete 72 hours. That's this course, Colorado contracts, plus also 24 hours of closings. That's if you miss one 4-hour class. Pretty wild. Let's go down to B3C. B3C down here. Each active licensed broker must complete an annual commission update course by achieving a passing score of 70%. It's a 10-question test, piece of cake. Very few people have a problem passing it. And courses excluded from continuing education credit, make note of these. This was on the state exam when I took it last month. Sales or marketing meetings, you cannot have things like this. It has to be real estate specific. You can't have sales or marketing meetings conducted in the general course of the real estate brokerage practice, or orientation, personal growth, self-improvement, self-promotion, or marketing sessions, motivational meetings, or seminars, or examination prep, or exam tech courses. So again, they mentioned 3 or 4 of those, and they say, which one of those can you not have as part of continuing education? And just look for one that is not real estate specific, and you'll be fine. And look on B10 on the next page. B10, each Colorado licensed broker is responsible for securing from the provider evidence of course completion in the form of an affidavit, certificate, or official transcript of the course. We'll give you a certificate when you take your continuing education from us, and if you lose it, give us a call. We'll just replace it. No big deal. And look at this B11. Each approved provider must retain copies of course outlines for 4 years. We keep all of our records, whether you're the employing broker or whatever. There's a 4-year retention requirement. We keep our records for 4 years. Go to page 2.8. Look at this C2, kind of above the middle of the page there, C2. Every resident Colorado real estate broker shall maintain and supervise a brokerage practice available to the public, except those brokers registered in the commission office as in the employ of another broker. What they mean to say there is that the employing broker has to have a place of business. He can't have just a post office box. It has to be a physical address. It can be a room in his house, that's fine, but it has to be a physical address. The exception is someone in the employ. As associate brokers, you don't have to have an actual place of business. Almost all of you will have a bedroom or something in your house. You're going to set up shop. Yeah, that's fine, but you don't have to. But your employing broker does. There has to be a place where they know they can reach them. Physical address. Down on the bottom of the page there where it says C16 down there, license non-transferable, it says that you can't loan your license to someone so they can do a couple deals and then give it back. Isn't that something? You know why they have that? Somebody did it. Isn't that wild? I'll tell you. You guys met any stupid brokers out there?
Yeah.
If you haven't, you're going to. And you know what? Every one of them passed that exam. And they can do what you can do. Let's go to the next page, C21. Individual proprietor may not appear to be corporate. If you're an individual, you're working as a one-person shop, you cannot present yourself to be corporate. I wouldn't worry about that right now. Nothing on the exam about it. Let's look at number 3 down below there, where it says, the broker applicant has been appointed by the board of directors to act as the broker for the corporation. This is different here. I highlighted this for a reason. It used to be that for a broker to become the employing broker for a corporation, he had to have a 20% ownership in that company. Not anymore. Not anymore. They just have to be appointed by the board of directors. That's all they have to do, is be appointed by the board. Keep that in mind. You will see a question on the state exam about that, guys. Don't miss that one. That's an easy one.
Number 3.
Yeah. Look on the next page. Look at C25, way down at the bottom down there. It says, notice of termination by the employing broker. It says that for some reason, I'm the employing broker of this company. If for some reason something happens to me and I fall over dead, I must immediately notify the real estate commission.
And that's so they can get a temporary.
That's strict. Yeah, that's really strict. You bet. So, look on top of page 211. Look at this D2 here. Inactive license request. A real estate licensee may request that the commission records show their license inactive. So you can get your license on inactive status. We're one of the few states that allow that to happen.
So does that mean you just don't have to take the test every,
Oh, no. You've taken the test, but you can't decide who to go to work for. But you want to get your license going. So you go ahead and pay your fee for it and everything, and they just put it underneath you, as underneath them actually as inactive. You maybe have to do something with it within a year. So the inactive license request, you can't have it in that. When I took the test way back when, I used to have someone to sponsor me to even take the course. Isn't that something? You didn't have to go to work for them, but you had to have a sponsor to even take the course.
Like a Series 7?
Yeah, kind of, yeah.
Yeah.
Series 7 is an SEC license, by the way. We'll talk about those too. Let's look at D3. An inactive license must be renewed. A real estate licensee whose license is on inactive status must apply for renewal of such inactive license and pay the required renewal fee every 3 years. You've still got to pay for the renewal. Told you about my buddies doing it for 25 years.
How much is the renewal?
Last year when I did, I think it was 160, but it changes every November. That's when they change it. And D4 here, renewal method using approved by the commission. Renewal of all license can be effected by use of the renewal application form provided by the commission or by other methods acceptable to the real estate commission. And licensee renewal notification. Notification that the license will expire unless renewed will be sent to the electronic mail address on file with the commission, whether it's to your employing broker or to you, actually.
What would be the benefit of having your license set on inactive?
I have to do something with it. It's been 11 years, it's 11 months since I took the test.
Right.
I've got to get it activated. So I'll just go ahead and pay the fee, and at least it's on record that I have it's in process, that it's done. It's just on inactive status.
Okay.
Because if you wait another month, you have to take the whole course and the test again.
Right.
Yeah, don't want to have that happen. And this is a biggie here on D7. Direct compensation from previous broker. When a real estate license is on an inactive status or has been transferred to a subsequent employing broker, a licensee may be compensated directly by a previous employing broker for compensation earned during that term of employment. So you go to another broker, that other broker still owes you money, they can pay you directly. Remember, you can only receive compensation through your own employing broker. This is one of the exceptions. Let's go to page 2-12. I like this. This goes into a lot of detail. Or middle of the page, B1. This is for our errors and omissions insurance, and we all have to have errors and omissions insurance. The ones that the Real Estate Commission recommends is a company called REIS, R-E-I-S. The real estate boards, like Jefferson Board and everything, they recommend a company called Williams. That's the one I always use, is Williams. But the one I recommend you guys get is called CRES, C-R-E-S Direct. Whatever your employing broker tells you, but CRES Direct, their fees are based on last year's production. And you guys didn't have any production last year. So it could be a nice, cheap way to go. CRES Direct. But don't think about errors and omissions right now. You have to have errors and omissions before you can get your license activated. But by then you'll know who you're going to be going to work for. And talk to them and see who they're using. They might have some special fees. Just like HomeSmart, they're such a big company, they probably get special deals through these errors and omission companies. So wait until you actually decide you're going to go to work for and then talk to them. Look at B1, middle of the page here. This is what it covers, and it's a really good policy. B1, coverage for all acts for which a real estate license is required, except those illegal, fraudulent, or other acts, which are normally excluded from such coverage. If we get sued for fraud, our errors and omissions does not cover us for fraud. Mortgage brokers have a $25,000 fraud protection that they have to have, as well as their errors and omissions. But we don't.
I have a question. So,
Yeah.
on the other end, if you are someone who feels that your realtor made an error, on the contract, or let something expire when she shouldn't have, or something like that, can you go back and sue her under the error and omissions, or for?
Oh no, in this case you get sued
No.
for errors and omissions. Yeah. you
Well,
could-
she's the one that, I mean, I'm saying, I'm the customer, she's,
Oh, yeah, when you sue your broker,
yeah.
that's when the errors and omissions kicks in, sure.
Okay.
That's what it's for. Yeah, and so this is the outline of this insurance policy that we have, and we all have to have this policy. My Williams policy runs me about $270 a year, less than $1 a day. Crest Direct's about half that. So it's really a good deal, and you have to have this insurance, and you want this insurance. Let's keep going. Like I say, it's rare that we get sued, but if we do, we have this coverage.
What are you seeing that they're being sued for? Like what's
Errors and omissions.
I mean, well,
It could be anything.
Ours, something ran out and she didn't tell us and she didn't amend it,
oh,
There it is, yeah.
so,
okay,
Yeah, that was an omission,
so we lost the house because of
yeah,
that.
okay.
yeah. So you could go after her for a lawsuit. She has
Well,
errors
it's
and
too late,
omissions
we didn't-
insurance.
I mean, we were young, we didn't know.
How long
Now
ago
we know.
was it?
Oh, it was over 10 years ago.
Was it really?
Yeah.
Let's talk about that for a minute. What's the law of limitations in Colorado? The law of limitations in Colorado is 2 years from discovery. 3 years if there's been fraud. So you could sue somebody or get sued for something that happened 8, 9 years ago. But after 7 years, it's pretty much set aside. But, again, that's how law of limitations work in Colorado. Let's keep going. Number 2, that the coverage cannot be canceled by the insurance carrier except for non-payment of the premiums when the event a licensee becomes inactive or is revoked or an application is denied a licensee. Number 3, proration of premiums for coverage which is purchased during the course of a calendar year but with no provision for refunds of unused premiums. So it's going to be prorated throughout the year. So you guys' errors and omissions will really be cheap this year. You'll just go till December 31st. Not less than $100,000 coverage for each licensed individual and entity per covered claim, regardless of the number of licensees or entities. So you have $100,000 per claim and an annual aggregate limit of not less than $300,000 per licensee. So $300,000 per year, $100,000 per claim. And coverage for investigation and defense shall be provided in addition to policy coverage limits. And a deductible amount for each occurrence of not more than $1,000. So you have $1,000 deductible, and the obligation of the insurance carrier to defend all covered claims, and the ability of the insured licensee to select counsel of choice.
So your maximum is, in the event that something were to happen, would be to meet your deductible, $1,000.
$1,000 deductible.
Legal fees, attorney fees, all covered.
Attorney's fees have no deductible at all, and the attorney fees are over and above the $100,000.
Right.
You might have $200,000 in attorney's fees. It doesn't cost you a dime,
Wow.
and you have no and you have again the $1,000 retainer fee. There is none for attorneys. Very cool, and this is a wonderful policy. It really works well. Again, attorneys, like I say, could be higher than what they're suing you for. And you don't have any fees for that at all. That's all included. And you can pick your own attorney if you want to, but you'd be foolish to, because that's what these attorneys do. What some brokers will do is they'll go ahead and fight the case all the way through and send a bill to the errors and omissions company. The errors and omissions company will not pay it. They want to fight that baby all the way through themselves. Or at least have a big hand in it. Okay. And then it says, coverage of a licensee's use of lockboxes, which coverage shall not be less than $25,000 per occurrence. If somebody uses the lockbox to break into the house, we have $25,000 of coverage. If they go and steal all the jewelry or whatever, we're covered. Pretty good.
Does that include damages to the property?
If they use it to get in the house, yeah, you bet. Williams came out with a statement. They've had millions of policies. They said they'd have 3 instances where people have used a lockbox to break into the house. It just doesn't happen. So
what if another broker's, left the lockbox, open or something like that?
well, that's how it can
They
happen.
still,
But that we're
they're
covered.
still liable?
We're still covered, yeah. So And
Just
the-
FYI, I just throw this out there. My broker, at the time we had our house listed, he told me to take the key out at night when we went to bed, and I did have somebody, I have a deadbolt, so there's no way they were gonna get in, but, I did have somebody, I was up at 1 AM and somebody was trying to get in, so.
What? Really?
Yeah, so, I just thought that was great advice that he gave me, cause I took it out at night and didn't keep it in the box.
Who was it? Do you have any idea?
Who was trying to break in? No, I have no idea.
You were actually trying to break in?
They were trying to come in.
With your lockbox?
Through my
Well, they're
lockbox.
trying to see the house. You never know.
Maybe they ran out of
At
town.
1
a.m.
Different times.
Because those lockboxes are pretty impregnable.
Yeah.
These are just breaking through the door, that lockbox.
Yeah.
Really. And then the ability of a licensee upon payment of additional premium to obtain higher or excess coverage if you want to. Or top of the next page, that coverage is individual and license specific and will cover the licensees regardless of changes in employing broker. You move your company to a different company, you're still covered. And the ability of a licensee upon payment of an additional premium to obtain an extended reporting period. And a conformity endorsement allowing a Colorado resident license to meet the errors and omissions insurance requirements for an active licensee in another group mandated state without the need to purchase separate coverage in that state. And prior acts coverage shall be offered to licensees with continuous past coverage. It's very important that you remember, let's say you put your license on inactive status for 6 months or for a year, you want to take a year off or whatever. And if your license is on inactive status, you don't have to have errors and omissions insurance. But if you cancel your errors and omissions insurance, you cancel any previous coverage that you had. So you go on that hiatus and you get sued for something that happened a year and a half ago, you're not covered. You've got to keep that policy in force. Or have a continuation coverage or gap policy coverage. You've got to handle that correctly. Remember that.
Does that guy that you were talking about who has his broker's license under inactive always keep his errors and omissions?
He doesn't have errors and omissions. He's never done a deal.
Oh.
Yeah, he's never activated his license, so he doesn't really need it. But like
Do they have a
in
different kind of insurance as a mortgage?
mortgage broker, yeah, as a mortgage broker he does. Oh yeah, you bet he does. But like I told you with my appraisal company, when I finally gave up my appraisal company, I called up at Williams, who I had my errors and omissions through. I had well over 300,000 appraisals, and I said, okay, I'm retiring. What's it going to cost me to make sure everything's covered? It cost me $14,000, but I had to sleep at night. You know, nothing ever came of it. Never had any lawsuits or anything. So I just kind of wasted $14,000, kind of, you know. But if I didn't pay that 14, sure enough, you know,
So
who
maybe
knows?
something would have happened.
Who knows?
I used to manage an appraisal company, and for all my appraisers, they had to have $1 million as their E&O. Why so much for them and not as much for realtor or broker?
Why so much that you have to ask them?
Yeah.
I never did with my people. No, that was plenty.
Yeah.
That was plenty because it was the same. It was the same as for a real estate broker.
It was the same.
This is what I record on.
Mm-hmm.
Well, it was this one place. Every guys ever heard of the Pagoda House? It was down in Pinehurst Country Club. And what happened is this house was something else. The guy who owned it was a Chinese chef. It was a $2.5 million house. And what happened? He had this kind of a stream going through his house, and you sat down in these kind of lotus blossom things, and you floated along and ate as you went along. It went all the way through the upstairs and then down the downstairs, then out the back and into the garden. Most amazing house you ever saw. Elvis slept there one time. Next to the house up in Genesee was the most famous home in Colorado. And 3 appraisers, including my firm, did an appraisal on this house, and they came in at $2.5 million. And what happened is these crooks bought it, and what they did is they just stripped it of everything. And then 2 years later went into foreclosure, and the lender sued us saying that we appraised that home for $2.5 million when it looked like that after it was stripped. It was so plain and simple. 3 different appraisal companies appraised at $2.5 million.
I'd be going to go see their house.
Did you really?
Oh yeah, it's sold for $850 or something recently.
Did it really?
Yes, it's the one that has the big pond in the front with the rocks, and then
It did, yeah.
it's got marble.
All over.
It's like big yeah. We
I
were
don't-
looking,
It was pretty amazing,
but it was in bankruptcy or something like
Yeah.
that, or auction or something.
well, this
Funny
is
that
this
you
is
say
this
that.
over 10 years ago when this happened.
Well, it went back again because this was
Yeah.
recent. I mean, I went to.
Yeah.
I'm pretty
Yeah.
sure it's the same house.
Probably down
Yes,
Pinehurst.
Yeah.
It probably is. Yeah.
Yeah.
But what happened is that you know it was a slam dunk case. Everybody knew what happened. Even those scumbag lawyers for the banks knew what happened. You know that we were innocent on this thing. Anyway, so I got a hold of the underwriter for Williams because we were in mediation then, going back and forth. And I told the head lady for Williams, I said, you know, they're suing us for $2.5 million on this deal. And it's slam dunk. There's no way that we were at fault on this. I mean, everybody can see what's going on. But I said, and I'll take this all the way to the Supreme Court if you'd like me to. But I'm not going to do it if our errors and omissions is covering us for $100,000. Raise it up to $2.5 million, and I'll fight this all the way. She said, we can't do that. She wrote a check for $300,000 that day. What a terrible miscarriage of justice that was. But you had to do it, had to play the game. Even though we were totally and completely innocent. There was no way I was going to take it any further. Because we could have got stuck with that $2.5 million. And we were just totally innocent. So again, things happen. Let's keep going. Page 2-14. It talks about errors. It talks about escrow accounts, and escrow accounts are OPM, other people's money. Whenever you have an escrow account, they're open for one reason, and that's to contain other people's money. Look at the last paragraph on page 214. This A down there. Accounts are in the name of the broker and the business entity. Like my escrow account is in my name, and of course in the name of the business. It has to be. And look on top of the next one. Accounts in the name of the employing broker only. And the main thing is, you don't ever want one of your brokers on the account with you. When you get to be an employing broker, we'll cover that in the trust account parts of the course. I have somebody like my sister or somebody on there with me, so if something happens to me, she'll be able to get the money out. And then C, escrow funds must be available immediately without penalty. That's the good funds statute. Make a note of that, the good funds statute. I've got to be able to get my hands on that money today. We'll talk about good funds many times in this course, and what the definition of they are, and of what they are, and what can be considered good funds.
Not the same as good faith?
Not good faith.
Okay.
Good faith. With good faith, what is a good faith? Good faith estimate. Who requires it? Who requires a good faith
Isn't
estimate?
it TILA?
Not TILA.
I don't.
Closing statement.
RESPA requires a GFE, good faith estimate. Yeah. But good funds is money that I get my hands on immediately. I put that escrow account. I can put it in bonds where it's nice and safe, but I can't get my hands on it today, so I can't do it. Safety's not the issue. It's the availability. I have to be able to get my hands on it today. And then commingling prohibited. A broker's personal funds shall not be commingled with money belonging to others, except an arrangement may be made with a depository to deposit a sufficient amount of a broker's funds to maintain such account. One or more separate account or trust bank accounts may be maintained by the broker pursuant to the following duties and limitations. Put down where it says may be maintained. We can have enough of our own money to maintain the account. That's how it is in the state exam. We'll talk about that in a couple more places also. Look at number 1 here. Money held in an escrow or trust account which is due and payable to the broker must be withdrawn promptly. Let's say that I'm making $15,000 in commission on this one deal. Then I've got $5,000 in the escrow account. So I tell the title company, who's closing the deal and writing the checks to just make a check out for 10,000. I'll get the other 5,000 out of the escrow account. Well, at the closing, when they hand me that check for $10,000, all of a sudden I've got $5,000 of my own money in the escrow account. That's commingling. I've got to get it out of there promptly. That's what they mean here. So if you see that question on the state exam, I'll hit you with it in class too. I have to have permission of both parties to do it. It's just a stupid thing. It's outdated. It doesn't happen anymore. But you'll see this question sometimes. In that scenario, I have to get that money out of that account promptly. That's the word to look for. Look at page 216. Top of the page F, it defines money that belongs to others. And some of you may not know this. This is money that is not yours.
Bless you.
So money belonging to others is money that is not yours. If you see some money laying there and it's not sure whether it's yours or not, guess what? It's not yours. Okay, so remember that. How about the earnest money on new construction? If you're selling your own house and you're not using a broker and you get an earnest money deposit, do you have to put that into an earnest money account? No, you can just put it right in your own checking account if you want to because it's your own house. Now developers do. They have to have an escrow account. Developers, remember, they don't have, the people working for them don't have to be licensed. They don't have to be licensed. They don't even have to use approved contracts. But they do have to have an earnest money deposit
Who are you
account.
just saying doesn't need an escrow account?
Of someone who, your own property, you're selling your own house.
okay.
Yeah, you don't need to have one
No.
if you're not working with a broker. But what happened is that several years ago, two pretty big builders here in town, Larson Homes and Falcon Homes, both went out of business. And there were some real concerns that their escrow accounts, in a bankruptcy, the last thing to be paid is unsecured debt. And that's what escrow accounts are. So there was some concern that these people get screwed out of their earnest money checks. And what happened, one guy had $72,000 in the account. Some of these high-end homes, when you upgrade it, you have to put the money in escrow for your tile and all that stuff. But anyway, they did end up building it out or paid the people back and everything was fine. But it could, again, it could be an issue when you were dealing with new home builders and the escrow checks that they had. This next part on H here talks about if I'm a property manager and I have 7 properties or more that I'm managing, I have to have a separate escrow account for every type of escrow that I have. Not a separate escrow for every property, but a separate escrow for every type of escrow. For security deposit, prepaid rent, animal deposit, whatever. If I have 7 or more units, I have to have a separate escrow account for every type of escrow. Now, if I have 6 units or less, I can just have one escrow account and just dump the whole thing in that one escrow account. But 7 or more, I have to have a separate escrow account for every type of escrow. Everybody okay with that? Now, let's take that another step further. This question on the state exam says there's a real estate broker who works as a real estate broker and also manages 6 properties. How many escrow accounts does he have to have?
2.
2. He has to have one for his real estate company and then one for the 6 units. Good question. It's a good question. It's coming at you, see if you
I
remember.
think the
There
question
you
you
go.
asked
What's
though
the
was
question?
7.
What's that?
No,
One of the
it's-
tests I think you asked was 7, so it would have been 3. Okay, I'm just saying. You
No,
had-
I wouldn't have because
Ah.
everybody has different number of escrow
Find
accounts.
it.
Yeah,
You know, all
No,
different
I'm
kinds.
trying to think of one of the way it was worded, one of the answers
he
was
collects
3.
rental for 2 landlords and also receives earnest money deposits on
For years.
sales. So he needs 2 trust accounts.
Yeah,
Okay.
that could be it. Okay. Now, then it says installment land contract on J here. Installment land contract. Next to that, many different names for this. Installment land contract, land contract. Owner will carry, contract for deed, all mean the same thing. Installment land contract, owner will carry. contract for deed. All mean the same thing. This is where the seller becomes the lender. Land contract, installment land contract, owner will carry, contract for deed. Just because it's called a land contract doesn't mean it's just for land. It can be used for any property. This is where the guy sells the property, has $200,000, he can put in the bank at 0.5%, or loan it back to the guy who's buying his house at 8% and have the property as security. He decided to do that. On an owner will carry.
He gets equitable title.
And you get equitable title until you pay it off, and then you get your deed. And we'll talk about that in greater detail later down the road here, but that's what installment land contract is. Very last paragraph on that page where it talks about earnest money. Checks received as earnest money under an earnest money contract must be identified as a check in the contract. How do we define what the earnest money is? In the contract is how we do it.
But it can be cash, right? Because that's not good fun.
It can't be cash. Right, we'll talk about that when we get to closings. Let's go to the top of page 2-17. Time limits on deposits of money belonging to others. So I'm the broker. How soon do I have to get this money into the escrow accounts? Let's read it. Top of the page. If you need to take a break, guys, take one. We're going to go straight on through here. Except as provided in Rule E10, all money belonging to others, which is received by a broker as a property manager, shall be deposited in such broker's escrow or trust account not later than 5 business days following receipt. So a property manager has 5 business days to get that any check they receive into that escrow account. 5 business days. All other money belonging to others, which is received by a broker, shall be deposited in such broker's escrow or trust account not later than the 3rd business days following receipt, and that is wrong. If I'm a regular broker and I receive an earnest money deposit, I have to get that money into the escrow account within 3 business days of notification of acceptance.
As a broker.
Yeah, let's talk about this. I put a contract on your property and I sign it. I sign the contract and I give it to you and you accept my offer and you sign the contract. Do we have a contract at that point? What do you think?
Not until it's accepted.
Not until I'm notified of your acceptance. That's when we have a contract. Even though I've signed it and you've signed it, I can still get out of it. Until I've been notified of your acceptance. At that point, I have 3 business days to get that escrow money into that escrow account. So a property manager has 5 business days from receipt. A real estate broker has 3 business days from notification of acceptance. And expect to see questions, especially on that 5 business days for property managers. Look on N. Listing broker holds the escrow funds delivered to third party, except as otherwise agreed to in writing in any real estate transaction in which one broker holds a listing contract on a property and where the selling broker receipts for earnest money under a contract. The selling broker shall deliver the contract and the earnest money to the listing broker, who shall deposit the earnest money in the broker's escrow or trust account in a recognized depository. And again, on the state exam, they use the term recognized bank depository, which is wrong, but it's just a little wrong. Just look for that on the state exam. And who can hold the earnest money? Let's read this number 1 here. The broker receiving for the earnest money deposit, if instructed in writing by the parties to the contract, shall deliver the earnest money to a third party or entity so identified in writing. If the broker is instructed in writing by the parties to the contract to deliver an earnest money deposit to such third party or entity, the broker shall retain in the office transaction file a copy of the earnest money check, note or other thing of value, including any endorsements, and obtain a dated and signed receipt from the person or entity to whom the broker has been instructed to deliver the deposit. And who can hold the deposit? Anybody can hold it with the direction of the parties. Who typically holds it? The listing broker. The listing broker holds the earnest money. And it talks about 5 business days, 3 business days. Is Saturday considered a business day?
Yes.
Yes, it is, unless it's a 3-day weekend. Then it's not a business day. Otherwise, Saturday is a business day. Okay, look at this number 1 down here. A record called an escrow or trust account journal, or an equivalent accounting system which records in chronological sequence all money belonging to others which is received or dispersed by the broker. This is the journal. Look at the next paragraph. A record collectively called a ledger, an equivalent component of an accounting system which records in chronological sequence all money which is received or dispersed by the broker on behalf of each particular beneficiary of a trust account. Keep your fingers here and switch over to chapter 20. Let's go all the way over to chapter 20, back of the book. 20, page dash 44. 20-44. We'll look at this a couple of times, actually. And keep your fingers there and go back to page 20-44. Chapter 20, page 44. And what we have here is a ledger card. Every time you have a client, you'll have a ledger card in that client. Every client you have a ledger card. And you'll make an entry in that ledger card, and then you'll have a balancing entry in your journal. There's only one journal, but a bunch of ledger cards. And so if you're a property manager, you'll have on page 44 here a ledger card, maybe for unclaimed properties. The one down below your company funds. You'll have a bank reconciliation worksheet on page 45. 46 is another ledger card. 47, another ledger card. 48, another ledger's card. Then if you go back to 43, there's your journal. There's your journal. You only have one journal and a bunch of ledger cards. And so we have a ledger entry and then a journal. Ledger, journal, ledger, journal. One balances the other out. So we know that we're keeping everything in chronological order. Question on the state exam says, where will we find a list of everything that's happened in a transaction in chronological order? The journal. The journal. Look for that one.
I remember you saying, I believe before, with the ledger cards, it's specific, so for each person you deal with, you would never combine 2 different people's information on one ledger card, is that
No,
correct?
just one ledger card for each person, yeah, or entity, yeah. Let's go to page 218, back to 218. And look on number 3. Look at number 3 toward the top page. A written monthly record called a bank reconciliation worksheet, which proves agreement on the date of reconciliation between the cash balance shown in the account journal and the sum of the cash balance for all ledgers and the corresponding bank account balance. The worksheet must be maintained in hard copy form for later inspection and list each beneficiary's ledger balance on the date of reconciliation. The broker is not required to reconcile any trust account when no money belonging to others has been received or no banking activity has occurred. So we have to report everything with every 30 days unless no activity has occurred on that account.
Who do you report to?
And again, to report to your client,
Okay.
to your client.
And this is the cash basis of accounting, correct?
Cash basis accounting, yeah, we'll cover that in just a few minutes here. Look on top of page 219, top of the page. Diversion or conversion is prohibited. Money belonging to one beneficiary of a separate trust or escrow account shall not be used for the benefit of another beneficiary of a trust or escrow account. And items instead of cash, any instrument or equity or thing of value taken instead of cash shall be held by the broker except as otherwise agreed. And again, anybody can hold it in the account if the parties agree. The listing broker typically holds it, the listing broker holds it, but the buyer's broker can hold it too. And this T down here, the number of accounts can vary from 0 to unlimited. Have as many accounts as you need to have. Look at this E3 here. And look at 1, 2, 3, 4, 5, 6, 7 lines down on the far left-hand side where it says however. This is where you're the property manager of a homeowners association, and another broker comes in. What do you do with all of the records and everything? Let's read this. However, a broker who is also acting as a manager for an owners association shall turn all association management records and supporting documents over to the association at the end of the broker's term of management. Such records are the property of the owners association, and if the broker wishes to maintain copies for the broker's own files, these must be made at the broker's expense. If I have a regular real estate company and another broker comes in, I just give the records to the new broker, but not in a homeowners association. Those records belong to the homeowners association. You're going to see something on the state exam about that. Don't miss it. That's an easy one.
So the records stay with the HOA.
With the HOA, that's who they belong to. Right. Look at page 2-21. Look at the second paragraph, C up there, where it says, closing statements shall be provided to the respective parties at the time of the delivery and acceptance of the title, whether such delivery and acceptance be effected by a bill of sale, deed, or by installment contract to give a deed at a future date. So when do we get our closing statements? At the closing table. Go down 2 paragraphs. If the licensee with whom the brokerage relationship has been established is unable to attend a closing or review closing documents, another licensee may agree or be designated as an employing broker to review and sign a closing statement, and will assume joint responsibility with the absent licensee for its accuracy, completeness, and delivery. So if I can't make a closing, I can ask someone else to go in my place, but they share my liability for everything accurate. So if somebody asks you to do that, don't do it for nothing. Make sure you get paid for doing that. There's a liability issue. Look at F here. A broker may transfer funds pertinent to a real estate transaction from a trust or escrow account to a lawyer or a closing entity acting on behalf of the broker at or before closing or final settlement. And the broker will not be relieved of responsibility in regard thereto. Most brokers use title companies for their earnest money, and if they do, they're still responsible for that money, even though the title company is holding it. And electronic records, can we keep electronic records? Of course we can. And that's what we do now. It's part electronic, part paper, combination of the two. Look at this A1 down here, advertising and names. Pursuant to the state statute, no broker shall be licensed to conduct real estate brokerage services under more than one brokerage firm. And no brokerage firm shall conduct or promote a real estate brokerage business except in the name under which that brokerage firm is licensed. However, a brokerage firm may use a trade name in addition to or instead of the brokerage firm's legal name with the permission of the owner of such trade name. And the trade name must be filed with the commission. A trade name is like Remax, Century 21, things like that. Those are trade names, and only the company has a trade name. The associate broker obviously does not have a trade name. Number 2, no broker shall advertise so as to mislead the public concerning the identity of the broker or the brokerage firm. Number 3, all advertising must be done clearly and conspicuously in the name of the broker's brokerage firm. A broker who advertises property owned by the broker which is not listed for sale or lease with the brokerage firm is exempt from advertising the broker's property.
Where would that be in this book?
In the
I
re-
can't
You know
find
what,
it.
that isn't even in that book.
I thought so. I was like,
Because it's a
I'm not-
brand new thing they just added, okay? And really, there's nothing in here that is really earth-shattering. Let's do this, let's go to page 2-23. 2-23, and let's go to E10. E10. Says licensed non-transferable, associates not independent or employing. A broker's license is not transferable. No license shall and no brokerage shall permit employed licensees to present or hold themselves out to the public as an employing or independent real estate broker.
Didn't we just go over that?
Yeah, like I say, they love repeating themselves, guys, so. And listings must have a termination date. They like the word expiry date. You can't have, I'm listing this property from August 3rd until sold. It has to have a definite expiration date. When a licensee secures a written agreement to perform activities requiring a license, a definite term for termination shall be included therein.
And no longer than 1 year, correct?
And the combination of the listing and the holdover period combined cannot be over a year. And there's the holdover agreement right underneath there. That's for anybody I show the property to, while I have that listing and I let the seller know I showed it to them, I can then bring them back after my listing expires and show them the property.
Is that the same as a holdover clause? The agreement and clause, the same thing?
The what clause? The,
Holdover clause?
that is the holdover clause.
Same thing. Okay.
That's the name of, yeah, it's called a holdover clause.
So,
And on the state exam, they errantly call it a protection clause sometimes.
oh no, I was just gonna say, well, I kind of went ahead to the sign crossing. So, since you work as a transactional broker all the time, it wouldn't be called sign crossing if another agent tried to get your clients, correct? Because they're not your clients.
No, the sign crossing thing is something we'll cover tomorrow, next session anyway, but the sign crossing is where you cross somebody's sign and give the owner one of your business cards and say, if this clown doesn't sell it, give me a call.
Okay.
You can't do that.
Got it.
Can't do that. Let's do this, guys. Let's go into your 3-ring binder and go to day number. Let's go to your second section. Your second section, Colorado contracts. And your big 3-ring binder. It's in your second section.
Contracts.
Second section. Desperate Colorado, day 2. Yep. Desperate Colorado, day 2. 89 is a page. That's kind of irrelevant, really.
I'm seeing just a contract.
No, you're in the contract. Go to the previous section. Yeah, the previous section of that.
Got it.
Yeah, previous section, not your contracts.
Which one is it?
You might have to have it.
Let's see there.
Purple. Okay, and is that the end of this?
No, it's in the beginning.
So I'm right, it's taken.
That's it. That's your right place. Yep.
I didn't see contract.
Okay, let's do these, guys. Now, these are not tests. This is study material. And all the answers are after all these questions, too. And yeah, you got to know every question in this 3-ring binder really well. The state exam will be as easy or as hard as you find this 3-ring binder. Let's go to 2-1 here. The manager of a homeowner association must do all the following except,
A.
do you have to have fidelity insurance? No.
D.
That's where no, that is the answer. You don't have to have fidelity insurance. If I told you mortgage brokers have to have $25,000 in fidelity insurance to insure them for fraud, but we don't. So A is the answer, number 1. Number 2, how much of his own money is a broker permitted to deposit and retain in his trust account?
C.
Enough to maintain it, right, C. A broker collects rental on 6 single-family homes under a management agreement and also receives an earnest money deposit on sales. How many trust accounts must the broker have? Two. Yeah. In Colorado, a buyer's agent has all the following duties except, the E word, except. And whenever you see the word only, that's probably going to be the answer. So it's D. Comply only with the requirements of the brokerage relationship law. No, there's other ones besides that. Which of the following need not be an escrow if received by a broker?
D.
Advertising expenses, advertising costs, D-Dog, right. Colorado subdivision registration requirements do not apply. We're going to talk about this later on in the course. Some of these are previews. To camping sites. We'll talk about this, camping sites. Errors and omissions insurance requirements include, we have to have annual proof that we have the insurance. A, annual proof. Let's go to 2-8. In which the following would you not find an entire record of a broker's trust account transactions? You'd find it in all the ledgers, you'd find it in the journal, you'd find it in all reconciled bank statements. You would not find it in the settlement statement. Those of you who've had closings know what that means very well. And number 9, if a broker does not receive a commission in a real estate transaction, the broker, we can never receive a fee from a title company. No matter what, they're always off limits. The answer is B, boy. At what stage must a broker disclose the fact that he or she is a licensed broker when buying or selling his or her own property? At the time of the contract. We have to state that we're a licensed broker for the state of Colorado on our own dealings. We'll talk about that in greater detail. And the entire record of a trust account transaction of a broker will appear in the journal. Expect to see that one again. Okay, that is the end of lesson 2.